Good day, ladies and gentlemen, and welcome back to another What If video. My name is Viapia, and as always, it is great to have you. Today's topic is, what if an employer terminates a fixed-term contract? Is such a termination a dismissal? Now, we see that employees who was employed on fixed-term contracts refer unfair dismissal disputes to the CCMA or to the Bargaining Council in terms of Section 186 1B of the LRA after such contract was terminated. The question is whether the ending of such a contract is a dismissal or not. Now, the answer to this question, ladies and gentlemen, is critical, because if it is found that it was indeed a dismissal, the onus is on the employer to prove that the dismissal was fair. In other words, if the ending of a fixed-term contract is a dismissal, the employer must prove that it followed a fair procedure prior to the dismissal and that it had a fair reason to dismiss the employee. Now, in proving a dismissal, the onus is not on the employer but on the employee. And in terms of a fixed-term contract, the employee must prove that he or she reasonably expected that the employer would, 1, renew the contract on the same or similar terms, but the employer offered to renew it on less favorable terms or did not renew it at all, or the employee reasonably expected that the employer would retain the employee on an indefinite basis on the same or similar terms as the fixed-term contract, but the employer offered to retain the employee on less favorable terms or did not retain the employee at all. Now, the test to determine whether the employee had a reasonable expectation is an objective one, and it involves a determination whether a reasonable employee would, in the circumstances prevailing at the time, would have expected the employer to renew his or her fixed-term contract on the same or similar conditions or provide the employee with permanent employment. Now, if the Commissioner finds that an employee had a reasonable expectation that the employer would renew a fixed-term contract on the same or similar terms, or to retain him or her in employment on an indefinite or permanent basis, and such expectations are not met, it is a dismissal. The onus would then shift to the employer to prove procedural as well as substantive fairness, as we know. Now, the latest case that dealt with the issues is the matter between Transnet, trading as Transnet Freight Rail, versus NUMSA. Now, the judgment of this matter was delivered as recent as 29 June 2021, and it is a Labour Appeal Court matter. Now, in this matter, the court was required to consider on appeal whether the employees in question had been unfairly dismissed in that they had an expectation of permanent employment that was not met. Now, let's just look at the facts. 2 employees in question, they were employed on 1-year fixed-term contracts by Transnet. One employee's fixed-term contract had been renewed 9 times and the other renewed 4 times by Transnet. On the 1st of January 2015, a collective agreement between Transnet and the representative trade unions was implemented, in terms of which it was agreed that Transnet would, from 1 March 2015 to 31 March 2016, 1 April 2015 to 31 March 2016, would appoint a minimum of 1,472 employees on indefinite employment contracts. During January 2015, the employees in question were informed by their supervisor that their fixed-term contracts would be renewed for a further fixed term on the same terms and conditions. Just note, this was after the conclusion of that collective agreement. At the beginning of March 2015, the employees were given letters to sign in which they were required to acknowledge that their fixed-term contracts would end at the end of March 2015. The employees then said no, they refused to sign this acknowledgement, as they claimed to be permanently employed and would not accept a further fixed-term contract renewal as a result. This is material. On 31 March 2015, with other contract employees, these employees in question were notified that their fixed-term contracts had in fact expired. The employees were not presented with new fixed-term contracts, given their refusal to acknowledge the expiry of their previous contract and to accept a further contract renewal. Employees were not happy with this outcome, so they referred a dispute to the bargaining council, where they claimed that they had been unfairly dismissed in that they held a reasonable expectation that their contracts would be renewed. So in November 2015, the arbitrator of this matter then found that the employees had been unfairly dismissed in that they had held a reasonable expectation of permanent employment. Transnet was not happy with this decision, and they took the matter to the Labour Court. And the Labour Court dismissed the review application, and in other words, the Labour Court agreed with the arbitration award that was made in the bargaining council. Dissatisfied with this outcome, Transnet then took the matter to the Labour Appeal Court. And the Labour Appeal Court, in determining whether there was a dismissal or not, considered the facts that the employees relied upon to bring their claim of dismissal within the ambit of Section 186(1)(b). In other words, what did the employees rely upon to prove, remember the onus is on them, to prove that they had a reasonable expectation of renewal. And the facts that they relied upon were the following. One, that their contracts had been repeatedly renewed. Remember, the one person was 9 times, the other person 4 times. Number 2, that they had been told that some employees would be made permanent as indefinite positions were created by Transnet. Number 3, that they heard the president announce on television that contract employees who had worked for more than 3 months would be made permanent. And then finally, that they had considered themselves to be permanently employed. So that was the facts that they relied upon. What was the court's analysis and decision on this? The court held that none of these facts supports a finding that the employees discharged the onus that rested upon them. The court said that on the employees' own version, they did not expect a renewal of their fixed-term contract since they considered themselves already to be permanently employed. Now, this was also the reason they refused to accept that their contracts had expired and why they therefore did not receive an offer of a further fixed-term contracts. The court said that the employees knew that Transnet intended to renew fixed-term contracts of employment, including their own. They were also told as much by their supervisor in January 2015, as we said. After the employees were informed in writing of the expiry of their fixed-term contracts, the employees refused to accept a further fixed-term contract renewal. And the court also concluded that any announcement made by the president regarding employment contracts does not support the employees' claim that they had been employed for an indefinite duration. Now, the court said, and I'll elaborate on this point a little bit more, but the court said that even if the employee's case had been that they held an expectation that their fixed-term contract would be renewed from 1 April 2015, the court said it was not their case, and the court concluded that the fact and their own conduct were destructive to such a claim. Meaning that if we look at the amendment to the Labour Relations Act in January 2015, with the whole deeming provision and the provision that deals with fixed-term contracts, that if you are employed on a fixed-term contract and you earn below the statutory threshold, that your fixed-term contract may not be less than 3 months. More than 3 months. If it is more than 3 months, the employer must have a justifiable reason for making the contract longer than 3 months. Now, in this case, if it was their argument that Transnet did not have a reason or justifiable reason to fix the term of the contract beyond 3 months, it may lead to this or contribute to an expectation being created. However, in this case, the employees did not prove that. In considering all that what we have now discussed, the Labour Appeal Court then held that these employees were not dismissed. In other words, the appeal was upheld. Ladies and gentlemen, that then brings us to the end of this video. Should you have any questions in regards to fixed-term contracts, Section 186, 1 of the LRA or section 198 capital B of the LRA. As always, never hesitate to contact us. I hope to see you soon, but until next time, bye-bye.